Yes, Vedya sir.
Lords,
Better. Yes, please.
Lords, may kindly have page number 8, my lords. There is an order passed by this honorable court regarding, my lords, stay of the order passed by respondent, my lords. Now, my lords, what happened, my lords, the persons who are creating some trouble against us, my lords, again they are, my lords, coming to my event and shouting slogans, my lords.
रेट का काम नहीं है वो आप
एक 110
Sir, how is the containment?
हो गया जी, एक
तो फिर आप जब मान नहीं गए don't
110
waste the time of the court.
एक 110 की भी एप्लीकेशन
Sorry,
110
here sorry. For what relief are you in the court?
बोली सिर्फ मैं बोल रहा हूँ जी एसपी साहब को ये बोला
सर
जाए
मेरा नहीं करना एसपी से मेरे को कोई प्यार नहीं है चलो
ठीक है जी मैं सिर्फ एक चीज मांग रहा था
Sorry, sir.
थोड़ा सा अगर
content dismiss. Mr. Vaidya, you should please apply your mind before filing such kind of application.
Please, ma'am.
And I'm saying it with a very serious note.
प्लीज माय लॉर्ड्स
Withdraw करने की order नहीं
कर लेता हूँ जी मैं
110 withdrawn है ना dismiss CPC COPC also withdraw.
प्लीज माय लॉर्ड्स
Wait for me. Still due course. Yes, Sani sahab.
Lordship, with the kind permission of this,
हाँ.
I want to withdraw these petitions.
The learned counsel for the petitioner. No, कोई liberty नहीं.
Liberty may kindly be given.
Then argue why cost should not be imposed upon the petitioners or misleading the court.
May kindly withdraw.
Huh? Simple withdrawal, dismissed as withdrawal. ये जिसमें मैंने cost डाली थी ना 1 लाख वाली, they want to withdraw. All interim directions stand vacated forthwith. All directions issued in the earlier order stand withdrawn forthwith. Palsra ji, ये क्या sir?
Lordship, I am for respondent 3, Lordship.
What is the matter?
Lordship, regarding the sewerage connection.
Notice sir 1 और 2 को सरकार 3 को आप reply in 4 weeks sir.
सब ठीक है.
Yes please, straight sharp. Yes please.
Though it's an assessment under section 126
हाँ.
and it is appealable under section 127.
हाँ.
Why I am before my lords, I take my lords to the order. Because there is a
हाँ.
lordship may have the order annexure P1.
ये सेम चीज है वही है
Same चीज है. इसमें इन्होंने
फ्रेश कर देंगे जी
प्रोविजनल भी नहीं
वॉश
दिया.
करके फ्रेश कर देंगे
इसमें लिखना नोटिस मैम एक्सेप्ट नोटिस ऑन बिहाफ ऑफ आप ऐसे करो रादर देन टेकिंग अ क्वॉशिंग ऑर्डर आप बोलो कि इसको विड्रॉ कर लेते हैं हम इनको फ्रेश करेंगे स्ट्रिक्टली इन अकॉर्डेंस विद 120 व्हाई टू टेक द रिट विड्रॉ
नहीं मैंने
कोर्ट से क्वॉश कर दें
हाँ
ओके लिखो सर विद द कंसेंट ऑफ द पार्टीज द रिट पिटीशन इज बीइंग डिस्पोज्ड ऑफ एट दिस स्टेज the petitioner herein is aggrieved. By way of this writ petition, the petitioner has paid for. Learned senior counsel for the petitioner has drawn the attention to order annexure P1 dated 28th of April 2025 and has submitted that the direction that has been issued with the impugned this is per se bad as the same is in flagrant violation of the provisions of section 126 of the Electricity Act. Learned senior counsel has submitted that in terms of the statutory provisions of section 126, firstly, the assessing officer has to send a provisional assessment, has to pass a provisional assessment order, copy whereof has to be provided to the concerned entity, calling upon the entity to submit its response thereto, and thereafter, after giving an opportunity of hearing the party concerned, the final assessment order can be passed. The senior counsel submits that nothing that said statutory that this statutory scheme has not been followed in the course of the passing of the impugned order. आप क्या कहते हैं? As a senior counsel for the petitioner submits that though the respondents do not admit to the contentions raised by the senior counsel for the petitioner, however, in the backdrop of the submission of the learned senior counsel for the petitioner, appropriate orders be passed, but the interest of the respondent corporate be also protected. Taking into consideration the fact that the primary challenge to the impugned order is on the is on the ground that the provisions of Section 126 of the Electricity Act 2003 have not been religiously followed. This petition is disposed of by quashing annexure P1 dated 28th of April 2025, but will liberty to the respondent board to proceed against the petitioner if so advised on the vis-a-vis the cause which led to the issuance of annexure P1, but by following the provisions of Section 126 of the Electricity Act 2003 in letter and spirit. Disposed of.
They'll pass on a list, they listed today.
इनको कर दो सब में P1 है डेट कर देना यस प्लीज डेटे चेक कर लेना
हाँ जी ग्रेटफुल लॉर्डशिप
मैं सुनीता आपके धनंजय सब में ही ना
हाँ जी
धनंजय की प्रेजेंस लगानी पहले ना और ऑन हिज इंस्ट्रक्शंस यस प्लीज
Lord, here I have challenged the reference of the dispute by the facilitation council to the sole arbitrator, which is in violation of section 18 of the.
देना जरा act them
Even though I have reproduced in my petition also
कहाँ पे
relevant sections.
कहाँ पे
Lord, at page number 21.
MSME Act
Page 20, 19 it starts, Lord. I'm sorry, those are the rules, but the provisions have at page 14, my Lord.
yes please read it
Lord, section 18. I'll be drawing my Lord's attention to subsection 3, my Lord.
हाँ
Start from the very beginning. Notwithstanding anything contained in the law for the time being in force, any party to a dispute may, with regard to any amount due under section 17, make a reference to the Micro and Small Enterprises Facilitation Council. On a receipt of a reference under subsection 1, the council shall either itself conduct conciliation in the matter or seek the assistance of any institution or center. Lordship, may kindly note these words, these two words, institution and center, providing alternate dispute resolution services by making such a reference to such an institution or center for conducting conciliation and the provisions of section 65 to 81 of the Arbitration Conciliation Act shall apply to such a dispute as if conciliation was initiated under part 3 of. Now, subsection 3 is important. Where the conciliation initiated under subsection 2 is not successful,
then arbitration
to either by itself or to an institution or center, providing alternate dispute resolution services for such arbitration and the provisions of the Arbitration Conciliation Act shall apply. Here what the council has done, my lord, if lordship will have P13 page 117, my lord. The order which has been passed, my lord, para 5, my lord, at page 118, whereas the council in its 86th meeting has decided to refer this reference to the arbitrator referred in to para 2 above and decided to hand over the reference to Shri so-and-so through email with the directions to the supplier to deposit the arbitration fee amounting to so-and-so. So my respectful submission is that this reference to the learned arbitrator is in violation of the provisions of section 18(3) of the Act. Since it is not an institutional arbitration, it is an ad hoc arbitration, my lord. Lordship, I'll be inviting my lord's attention to a few judgments of the Honorable Supreme Court as well as Delhi High Court and
so show me Supreme Court
please, my lord. The compilation, my lord. Shilpi Industries, my lord. 2021 volume 18 page 790, my lord.
ये Supreme Court cases 2021 volume 18 yes Mr. Smith
Please, my lord. Lordship may have para 31 and 33 of this judgment, my lord.
okay please read it
Please, my lord.
31 is that page
My lord, page 23, my lord.
23 yes, please read
I'm sorry, para 33, my lord. At page 24.
Okay.
From a reading of section 18(3) of the 2006 Act, it is clear that when the conciliation initiated subsection 2 of section 18 of the Act is not successful, the council shall either itself take upon the dispute for arbitration or refer to any institution for arbitration. Further, Section 18(3) of the said Act also makes it clear that the provisions of 96 Act are made applicable as if there is an agreement between the parties under subsection 1 of Section 7 of the 96 Act. Section 23 of the 96 Act deals with the statement of claims and defense. Section 23(2)(a) gives a right to the respondent to submit a counterclaim or plead set off with regard to claims within the scope of arbitration agreement is brought into statute by amending Act 3 of 2016. If we look at the statement of objects and reasons of the amending act, the same is enacted to provide the speedy disposal of cases relating to arbitration with least court intervention. Clause 11 of the bill, by which subsection 2A was proposed to be inserted, states that subsection 2A was intended to give an opportunity.
So where does it answers the issue being addressed by you?
Lordship may have para 37 now. Page 26 of this compilation. The 2006 Act contemplates a statutory arbitration when conciliation fails. A party is covered by the provisions of 2006 Act, allows a party to apply to the council constituted under the Act to first conciliate and then arbitrate on the dispute between it and other parties. There are fundamental differences.
No, you see, your primary contention is that the reference of the arbitrator to the learned retired district and session judges. That issue is not answered in this one.
I'll just point out. Then Lordship may also have these two judgments from page 31, my lord. This is Delhi High Court and para 17 of this judgment.
Let us read that.
It is at once, Lordship has page 35. It is at once clear that the provision of section 18(3) of the Act do not leave any scope for a non-institutional arbitration. In terms of section 18(3) of the Act, it is necessary that the arbitration be conducted under the aegis of an institution, either by the MSEFC or under the aegis of an institution or center providing alternate dispute resolution services for such an arbitration. Then the provisions are extracted, my lord. Then para 28, my lord. The court for the reasons, that is at page 37. The court for the reasons as stated herein above is unable to subscribe to the view that there is no inconsistency between the arbitration agreement and section 18(3) of the Act. Section 18(3) contemplates only an institutional arbitration and not an ad hoc arbitration. In the present case, provision of that only BHEL would appoint an arbitrator plainly runs contrary to the mechanism under section 18(3) of the Act.
But there is a problem, even as far as this judgment is concerned. Contention of BHEL or whichever was the party, unki contention ye thi that because as per the arbitration agreement probably right was conferred upon them to appoint an arbitrator, so they were insisting ki arbitrator hamara hona chahiye. There is
no arbitration.
That is a separate issue. The moot issue is this. So where the Honorable Supreme Court, where the Honorable Delhi High Court talks about ad hocism the word has been used in the context of one of the parties insisting before the Honorable High Court ki not the arbitrator appointed by MSEM, but the arbitrator envisaged in the agreement. Under the agreement.
Here there is no agreement itself.
I agree. You are drawing strength from those three lines that have been moot issue before this court is as to whether the MSEM in such like manner can refer the matter to an independent arbitrator. He's an independent arbitrator. Rather than referring,
I would rather submit he's an ad hoc arbitrator.
But what about so many awards that have been passed by such an arbitrator?
That would be rendered honest, my lord, because
this is one view.
Because what is happening is,
okay, we'll directly
it could have arbitrated itself, my lord, because the provisions of 18(3) categorically speak that when the
where the words institution or center providing alternative reduce have they been defined
in the rules, my lord?
Let us see that.
The rules are at page P20, my lord, page 177.
Okay, please read them.
Please. Institution at page 178. F, my lord.
So according to you, the MSME can only fall back upon either an institution which is providing
Alternative
resolution
services.
and it cannot appoint any individual to arbitrate between the parties. Notice.
And rule 3, sub rule 9 also, my lord.
Rule 3
Rule 4, sub rule 9, my lord.
Please read it.
Where the conciliation is not successful, it is at page 173 and stands terminated without any settlement.
ठीक है, लिखो सर इसमें नोटिस 1 और 2 को नोटिस 3 को तो क्यों भेजना?
Because he started with the proceedings.
इसको नहीं तो आप you have not appointed, you have not made the arbitrator as a party. 3 तो MSME.
Then MSME has made the reference to the arbitrator.
MSME is not a necessary party according to me. MSME ने वैसे भी नहीं आना है. MSME is just a statutory body. It is just like Honorable the Chief Justice appointing an arbitrator. If one is aggrieved, he will not array Honorable the Chief Justice as a party response. Notice confined to 1, 2 and 4. 1 और 2 के लिए सरकार notice to respond number 4 return for dash within 1 week.
Lord, may I make one submission? On my oral request, the learned arbitrator may be added as party.
आप उनको बनाते रहो. In the meanwhile, I'll stop the.
Please.
I don't think he's a necessary party.
Please.
He's not to defend here the order part.
Obviously, because he's been.
इसलिए इसमें करना notice in above terms. Learned senior counsel for the petitioner has drawn the attention of the court to the provision of subsection 3 of section 18 of the MSMED Act 2006 and also to rule 2 within bracket F and 4 within bracket Roman of the MSMED rules 2018 and submitted that the statute as well as the rules clearly mandate that if conciliation is not successful and stands terminated without any settlement between the parties, then the council shall either take up the dispute for further action, that is arbitration, or refer it to an institution for the same. The senior counsel has submitted that the institution stands defined under Rule 2F of the 2018 rules, and there is no provision that in such like situation the matter can be referred to an independent arbitrator, as has been done in the present case by bypassing the provision of subsection 3 of section 18 of the Act. Having heard the senior counsel, view that there is prima facie force in the submission so made by the senior counsel, till further orders, the operation of annexure P13 dated
24th May 24.
Stand state is hereby state, and it is ordered that arbitration proceedings shall not be undertaken by the learned arbitrator appointed in terms of the interim law. I hope started.
He's underway.
In case the arbitration proceedings already stand, initiated by the learned arbitrators who appointed, he shall not further proceed with this. Yes, please. Mukul.
Here's the matter, Lordship. We have the petitioner invoked the jurisdiction of the civil court, Lordship, and got the degree, Lordship. And thereafter, the demarcation was also taken place, Lordship, with respect to a pool which is just adjacent to his property, Lordship. The private respondent have encroached upon the pool, Lordship, and the municipal corporation itself has made a path on that pool, Lordship, without there being and the pool itself has been deviated to the land of the petitioner, Lordship. That has come in the number of courts, Lordship. Petitioner thereafter taken up the matter with the authorities with respect to the further proceeding under section 163 of the Act, Lordship. But those had not been taken, Lordship, despite he is continuing from making the representations and
नोटिस एक और दो के लिए सरकार 1, 2, 4 and 5 तीन को नोटिस रिटर्न, तीन से और बाकियों को रिस्पोंडेंट रिटर्न फॉर दैट। ये देना सुनीत को देना। Yes, please.
In this petition, one of the land of petitioner has been acquired by respondent for the construction of 4-lane project, my lord. And my lord, despite the land has been acquired and is.
ऐसे जमा करा दिए हुए हैं?
Yes, my lord.
They are not releasing. Kala is not releasing.
The reason behind it is because we have filed the claim petitions. My lord, the amount was deposited under protest, my lord, but because the cases arbitration.
I'll reply.
Please, my lord, I'll file reply.
Notice.
Arbitration cases are going on, so if we will release all the amount, then we will have, because the undisputed amount has been released.
So just 1 minute. Ma'am, if arbitration is going on, you move appropriate applications before the arbitrator.
And they are part in that.
My lord, otherwise the instant is amount is deposited opposite party, they have to release it then and there.
Like, go to the arbitrator.
My lord, kindly ask them.
No, sorry.
50% amount.
Petitions are not maintainable. How? Sekho, you cannot sail in more than one boat setter at one time.
But my lord, in certain they have not even made us party.
इसमें
Arbitration.
आई एम नॉट, यहाँ पे कोई ये रामायण नहीं लगी, मैं सिर्फ एक अध्याय पढ़ रहा हूँ अभी,
Yes,
ठीक है
ma'am.
ना हेमराज, इससे बाहर मेरा केस नहीं है। इसका what learned counsel for the respondent is submitting is
Yes, ma'am.
that they have assailed the award.
Yes, ma'am.
Whatever according to them is payable, they have already paid. Supposingly the order is passed that pay everything and they succeed to what they will recover.
That is
Dismissed.
50% has been released.
Withdraw कर लो चुपचाप.
Then my lord, let me withdraw.
After making her submission, sometime notice करके withdraw. चलो जी.
With the permission to go before the appropriate authority. my lord.
With liberty to approach the learned arbitrator. It is clarified that this court has not expressed any view. In the light of the it is क्या लिखा आपने? Learned arbitrator. In case of any such application being filed before the learned arbitrator, the contention of the respondents be taken into consideration.
My lord, the arbitration is going on since 2023.
आप ऐसे करो. Permitted to withdraw this petition in the light of the fact that the matter is already pending in arbitration proceeding. We stand initiated by NHA.
Please, your lordship. Sir.
Bas.
Right.
Yes, please. Dr. Lalit.
My lord, here, wide and actual P3 lordship, page 34 lordship.
Yes, sir.
First of all, lordship, I am very sorry, lordship, because in a hurriedly manner, lordship, because the general house meeting is convened on 8th lordship, so I could not get it, lordship. These are all in the vernacular copy.
कोई बात नहीं है, क्या issue क्या है sir?
My lord, here, wide and actual P3 lordship, the notice to the present petitioner, he is one of the members of this particular society lordship, respondent number 4 society lordship, which is a transport cooperative society lordship, with attached with that Baga lordship, cement factory lordship. Their lordship now they are lordship going to convene a general house meeting on 8th of June 2024 lordship. So lordship, my lord may have next P2 lordship, page 32 lordship. The last meeting of the general house was convened lordship on 3/9/2023 lordship, which is reflected from subjective lordship. The विषय द्वारा रखे गए 3 को साधारण जनरल अधिवेशन द्वारा जानकारी प्राप्त हेतु लॉर्डशिप. So lordship, now lordship, my lord may have the provision of the act lordship, that the what is the procedure prescribed for the convening the general house lordship. My lord, kindly have the copy. Act lordship, section 38 lordship, section 32. Yes.
Section
32 of the SP Code Society Act. Prior date of 31 authority is the general house, which is the supreme authority for the Quadis society laws. 30 laws is the annual general meeting. A general meeting of every society shall be held once at least in every cooperative year for the purpose of A to E lordship, those are the approval of the program, the activity of society prepared by the committee for the ensuing year, election if any prescribed in the manner of the committee other than the nominated member, consideration of the audit report and the audit report, and the disposal of the net profit, consideration of any other matter which may be brought to in accordance with the bylaws. Such meetings shall be held.
Mr. Sharma, how is this petition maintained?
Please, Lord. First of all, let me submit, Lord. This provision, lordship, says, lordship, that the maximum ceiling, lordship, which is available to the society lordship to convene the general house In case salient feature of the annual general meeting is not convened by the society lordship, then at the maximum ceiling is 18 months, lordship. Thereafter, lordship, the permission, there is even assistant registrar has no authority to lordship to direct the to give accord the permission to society to convene the general house at their own level, because the proviso to lordship it says, because that mandated it is the duty is cast upon the authority, statutory authority, to convene the general house, so that society at their own level, lordship. So in the present case also, lordship, with the nature of P2, lordship, the last lordship, the meeting was convened on 3/9/2023, lordship. That period lapsed 18 months, lordship, in the month of March 2025, lordship. Then, lordship, when lordship, I got the knowledge that the lecture P3 was heard, I asked the assistant registrar, lordship, I apprised him, lordship, that you kindly supply me and intervene, lordship, and the lecture P6 is the last, lordship. When I, on second occasion, I visited him, that you supply at least that if this permission has been accorded to the society.
So it is an issue between you and the society. How is the High Court concerned?
Hello, this statutory, because that is the control. General house is convened by the invocation of the section 32, lordship. So there the statutory authority, because
So where is the order passed by the statutory authority?
he says, lordship, that you get this order under the RTI, lordship. In the initial stage, he says,
Grievance क्या है?
मेरी grievance है, lordship, because this section 32 proviso 2 के तहत the society at their own cannot convene the lordship general house. It is this statutory authority, that is the respond number 3, assistant registrar. He convened.
Where is the order in terms whereof the general house is being convened?
Well, that lordship, because मैं यही बोला जी इनको, because I am saying that अगर नेक्स्ट P3 देखें ना सर, इसके अंदर there is no mention that the whether any permission. So I have stated in my petition two kind of petition. The lecture P3 nowhere suggests that yes, whether the society ever obtained the permission to convene the general house from the ARA, lordship.
No, please read your prayer clauses.
Yes, lordship.
Issue a writ of certiorari, impugned order 3/25. Where is that order?
Yes, lordship. Lecture
Let us read that.
Add notice, lordship. Lecture P3, page 34, lordship.
Let us read that.
Yes, lordship. यह है जी सभा के वार्षिक अधिवेशन की सूचना के बारे में। दंड महोदय, राज्य सरकार उपरोक्त विषय के संदर्भ के साधारण अधिवेशन दिनांक 8 जून 2025 में 10 बजे स्थान लाड़ा घाट ढोलका में बुलाया गया है। तो आप उपरोक्त स्थान पर वर्षा व चर्चा व विचार हेतु भाग लेने की अनुकंपा करें। अधिवेशन में नियमित एजेंडे विचार चर्चा एवं स्वीकृति के लिए रहेंगे। एजेंडा 1, सभा के वर्ष 2022-23-24 व टेंटेटिव रिपोर्ट 2024-25 के आय व्यय, लाभ हानि व अवशेष पत्र की स्वीकृति व चर्चा पर। नंबर एजेंडा 2, वर्ष 2022-23-24
So this is a notice for the convening of the annual general meeting committee. How are you aggrieved by it?
Because my lord, my attack is, lordship, this lecture P3 as per the lecture this lordship section 32 and
Please read it.
Rules are also seen, lord.
Please read it.
Please, lordship. I will again section 32, lordship. My lord, clause 2, such meeting shall, because the annual feature is a lordship, the salient feature is annual feature, convene the general house on the annual basis, lordship. The clause 1 says, lordship. Number 2, such meeting shall be held not more than 15 months after the date of the last preceding meeting held under subsection 1, provided further that the registrar may, by general or a special order, extend the period of holding such meeting for a period of
So when was the last meeting?
3 months.
So when was the last
18 months.
When was
Now,
the last meeting held?
एक लगा देख लेंगे दोबारा अगर next.
When was the last meeting? Will come.
Last was convened, lordship. It was the lordship as per next P2 on 3/9/2023.
3/9/23.
That 18 lapsed in the month of March 2025.
Pado proviso, sir.
Yes, sir. Second proviso.
Please read it.
Provided that if in the opinion of registrar no such extension is necessary, or if such meeting is not called by the society within the extended period, if any, granted by him, the registrar or any person authorized him. My lord, here I am posing. Registrar, either himself or any person authorized by him, may call such meeting in the manner prescribed, and that meeting shall be deemed to be the general meeting duly called by the society and the registrar may order that the expenditure incurred in calling such meetings shall be paid out of the fund of the society or by such person or the person who is, in the opinion of the registrar, responsible for the refusal or failure to convene the general meeting in laws. So here I am
आप
saying
किसके लिए पेश हो रहे हैं?
is society के लिए.
So what is your reply? According to him, the annual general meeting was not held within the statutory period, and if it is not held within the statutory period, then there is a procedure which has to be followed. According to him, the procedure has not been followed. What do you say?
Lordship, here says, Lordship, in case if it is not held within 12 months and initially after extended period of 3 months,
3 months.
3 months, then the registrar may call. What is may? May call, but it did not call. It was incumbent upon the registrar in case if the society is not convening the general board meeting within 15 months, then registrar may call.
Registrar को ख्वाब आएगा?
जी.
Registrar को ख्वाब आएगा कि इसमें election नहीं हुए हैं. It is for the society to approach the registrar.
Election नहीं जी, general voting.
General house की भी बात हो रही है. The proviso does not deals with election. It deals with the holding of the AGM.
जी.
The second proviso is very clear.
जी.
Second proviso is that if all this is not held within 18 months,
जी.
then there are two courses available with the registrar.
जी.
Either on an application filed
जी.
by the society
जी.
for the holding of AGM
जी.
beyond the period, he may say that okay,
जी.
you may hold it and I am ignoring the delay.
जी.
Or what he can do is he will hold the meeting himself and recover the expenditure from the persons who were at the helm of the affair. So
my humble submission is that, Lordship, that when the registrar reason because every general voting proceedings are held under the Lordship supervision of the authority. And
answer the question of the court. Have you obtained any permission of the registrar for holding this meeting?
Lord, it may be possible. I will be seeking instruction. Reason because petition of the copy of petition is also supplied right now.
तो फिर मैं नोट स्टे कर देता हूँ अपना.
जी, इसको थोड़ी सी पास ओवर.
और वैसे भी ये तो कब के लिए रखा हुआ है?
Actually reason is, my lord may see. Actual reason is, my lord, in this agenda number 5 is actual issue of contention. Yeah, society had wanted to install its own petrol pump, but all these petitioners.
Immaterial. Court is not concerned with petrol pump or electricity pump. Issue is that the society loses the right to convene AGM after 12 months.
I'm just saying, Lordship, it's maybe short pass over, Lordship.
Pass over. Next. Yes, sir. Like round. Yes, please. Like Ram Krishna Sharma, Bhimraj Sharma. Yes, please.
Lordship, in fact, this is the litigation between this petitioners who are of the respondent number 6 society. And this
Agar land loser, sir.
Agar land loser.
Let it go before some other land. Just before another mention. Yes, please. Yes, sir.
My lord, Krishna is a small scale proprietary firm, my lord, having the drugs license, manufacturing of drugs license till 2026, my lord. My lord, one complaint was registered against me under the Drugs and Cosmetic Act, and during the pendency, my drug license order for non-stop manufacturing order were passed, my lord. That till pendency of the case, my lord. And my entire property and premises were seized, my lord. When the investigation was complete, we moved the application before the trial court, and our premises and our equipment were released, my lord. And premises were de-sealed, my lord. And my lord, thereafter we apply for the revocation of this stop manufacturing order, my lord. And upon my application, the respondent number 3, drug controller, had made a joint committee, my lord. Joint committee, regulatory committee inspected the premises, my lord. And thereafter, it was recommended by the regulatory authority.
Yes, yes.
It was recommended by the regulatory authority that this stop manufacturing must be revoked, my lord. And the investigation is also complete. But to the great surprise, my application was rejected, my lord.
Mr. Guleria,
Yes, my lord.
you see, because no interim can be granted to you at this stage, we'll direct them to file reply. Huh? Notice accepts notice, reply in 4 weeks.
Grateful, my lord.
Yes, please. Yes, Gil sir.
Yes, my lord. What in this petition, my prayer is twofold, my lord.
Uh.
First, my lord, I was illegally framed by the police authority under NDPS Act, and in support of that, I have relied upon.
I fail to understand.
Yes, my lord.
Honestly speaking, at least Mr. Gill, आप करो बहस करो.
Yes, my lord. First, in support of that, my lord, I have certain recordings.
Sorry, go before the trial court. Whether or not a person is guilty, it is to be established before the trial court. High court सब ये adjudicate करेंगे 226 में whether a person is guilty of the allegations or not.
My lord, second fold of prayer, my lord.
You see, and I'm warning the petitioner. If the court comes to the conclusion that these kind of petitions are abuse of the process of law, I've been lenient till now. I will impose cost not less than 10 lakh rupees. Now, let me be very clear and candid. Because when we read these petitions in our chambers, one really is shocked that to what extent, as to how the parties are being advised to file the petitions. I'll not say anything more.
My lord, second prayer, my lord, my arrest
इसको नहीं पता
per se illegal, my
जो
lord,
भी है.
because grounds at the allegedly, my lord.
And where are you now?
I'm behind the bars, my lord.
By virtue of judicial order.
By virtue
And what is the law?
that
What is the law on this subject?
is, my lord.
What is the law on this subject?
My lord,
What is the law? What is the law declared by the Honorable Supreme Court with regard to the allegation of an illegal arrest, which ultimately culminates into a custody by virtue of a judicial order? Honorable Supreme Court is very clear that except for that Madhu Limay principle,
please, my lord.
if you are aggrieved, challenge the order passed by the judicial court.
But honest, my lord, when I was,
Mister, ऐसा है ना?
but this is a
Show
recent.
me the law. मैं आपको दिखा देता हूँ मेरी PMLA वाली judgment को जो मैंने परसों चौथ अनाउंस की.
Please, my lord.
All the judgments stand quoted there. What is the law?
Please, my lord. Here,
ये कौन सी है?
sir, Bihan Kumar, my lord.
हाँ?
Bihan Kumar.
मैं आपको भी देता हूँ. मेरी निकालना जरूरत नहीं.
My specific issue, my lord, plea, my lord, before this court, my lord. Since the grounds of arrest were not furnished, therefore the arrest is.
We'll issue notice and file the receipt. Notice. 5-1. Who is number 6? How are they? How is this one number 6?
My lord, he is the person, my lord. He's also involved, and I have leveled allegation against that person also, my lord, because transaction is there, my lord, with respect to that person also, my lord. And he is the in charge, my lord. In the residential, my lord, room, I was apprehended, but it is totally incorrect. That rooms belongs to the gentleman.
When were you arrested?
I was arrested, my lord, on 17th, my lord.
Of
Feb.
17th of February.
Please, my lord. I have.
अब मैं इसको pass over करता हूँ. You just have instructions whether grounds of arrest were made available to him on.
Please, my lord.
निकालना जरा वो judgment PMLA. Yes, Atri Saab.
Is your lordship. Your lordship, this by way of this writ petition, I have challenged the order passed by Naib Tahsildar, who acted as sub registrar, whereby your lordship, my seal deed have been declined to register on the basis of one letter issued by chairman of RERA that.
So there is no authority between sub registrar and the High Court who can look into the grievance of the petitioner.
Your lordship, I'm getting it. Your lordship, my lords may be referring of the RERA.
नहीं मेरे को नहीं पता. मैं तो एक
lordship for
तो हवा में ऐसी जाल फेंका आप ऐसी फंस रहे हैं.
नहीं जी मैं फंस नहीं. Your lordship, for that purpose, your lordship, because the sub registrar, the order passed by sub registrar does not come into the purview of the tribunal.
Okay, no problem.
Yes, sir.
Is there no authority superior to sub registrar who can address the grievance of the petitioner?
Your lordship,
कितनी authorities हैं between the sub registrar and the High Court under Article 226?
there are
How many authorities?
Your lordship,
Approach them.
may I submit, your lordship? May I submit? Because in this case, your lordship, there are two authorities, your lordship. One is the sub registrar, another one is the RERA, your lordship. I have challenged both the orders, your lordship, and the order by RERA, Your Lordship, it was not a direct order to me, Your Lordship. It was a communication by the chairman of RERA to the Tehsildar. And what, Your Lordship, if my Lord may see, I'm selling my entire share of land. RERA and Town Country Planning Act, they restrict if there is a sale of subdivision of land, Your Lordship. But it is not a subdivision of land. It is a sale of.
के ऊपर collector बैठा हुआ है. Why don't you approach the collector?
Lordship, only for the reason because I represent the deputy commissioner.
Because Mr. Vivek Atri does not.
Lord, may I submit? I represented to deputy commissioner also, and Your Lordship, in this, Your Lordship, the entire land is being used for agricultural purposes, Your Lordship. I have, Your Lordship, may I submit? Only for 2 minutes, if my Lord may indulge me.
मैं घड़ी देख रहा हूँ, आप बहस करो.
Is much obliged. Your Lordship, as far as town and country planning and RERA are concerned, Your Lordship, because letters have been issued by assistant town and country planning officer, Your Lordship, for the land which is not even owned by me, Your Lordship. Right. There are a lot of khasra numbers.
I am not into the justiciability of the issue being raised by you.
Yes, Your Lordship.
I am on the issue of maintainability of the deed.
Yes, Your Lordship.
You have many authorities between the officer who has passed the order and the High Court who you can approach at this stage. So court is asking you not to rush to the High Court. Approach the authorities by challenging the order. Representation नहीं होगी. अगर आप aggrieved हैं किसी order से, challenge it before the authorities concerned. If you are unsuccessful till the stage of secretary, then come to the High Court. उससे पहले नहीं.
Your Lordship, because I have referred to, Your Lordship, the certain provisions which
are the authorities incompetent to read the provision?
Not at all, Your
Lordship. Are they illiterate?
Not at all.
And
at all, Your Lordship.
What kind of arguments are being addressed in the court?
Because the entire land is being used for agricultural purposes.
मैंने क्या लेना देना उससे? I have not questioned you कि agricultural है. I have just posed a query to you.
Please, Your Lordship.
High Court principle of writ jurisdiction is
alternative.
Sorry, there are two words known as finality clause.
Yes, Your Lordship.
When an order attains finality,
yes, Your Lordship,
and it cannot be assailed under section 9 of the CPC, then you come to the High Court under 220.
Please, Your Lordship.
Where is finality clause in this? And this we were taught when we were in the first semester itself.
Please, Your Lordship.
Next case.
Your Lordship,
When it comes for the petitioner, praise for is permitted to withdraw the petition with liberty to agitate the issue before the appropriate authority. Next case.
Much obliged.
Yes, Ms. Kotwal.
Of the husbands of the respondent, present petitioner, the Kalandra was present. Respondent number 5 under section 107, 150, and 145 of the CRPC. Not.
Ma'am, how do you explain the delay of 4 years?
Lordships, but your lordships are kind enough. This is the case. Not only I am agreed by the impugn order. This is the case where I am agreed by the acts and conducts of the authority itself. It is only after 2 years when the petitioner exercised the RTI, she was supplied the copies of the entire record. The case is basically, lordships, regarding the harassment which has been faced by the husband of the petitioner.
When the sub-divisional magistrate is exercising powers under CRPC,
you
can always assail that order under the provisions of CRPC itself.
That is true, absolutely correct, lordships. But here, lordships, my contention may be seen, lordships. The lordships are kind enough to have the next P9 page.
That is, I have opened that only.
Page 9, lordships. Despite of the respondent number 4 taking the opinion that there is a likelihood of breach of the peace, the respondent number 5 was never asked to furnish the surety bond as per section 107, and there is the courage of the justice for not following the procedure of the law.
You assail the order under the provisions of the act under which the authority has exercised its jurisdiction.
Lord. Apart from that, IBO lordships. Here, my specific allegation in all my emails, lordships.
Please,
I'll give a little background of the case.
Please, जब आप appropriate proceeding file करेंगे, take all these please therein.
Only one submission. Taking the advantage that the sons of the petitioner, those who are the owners of the land settled in the abroad, the complainant who expired only last year, lordships, he was harassed by the authority itself, was not given the information for the status of the case for the 2 years, and thereafter the present petition has been filed seeking the justice before this honorable court, and even the council
just
counsel of the petitioner was threatened by the dealing hand of the respondent number 4 that you.
I hope the council has filed an FIR or has taken appropriate action. जो भी है, ये नहीं है मैम. No emotions here. Only legal arguments.
मैं humbly submit.
Please.
Liberty में kind.
Yes, I am giving you. इसमें लिखना by way of this petition, the petitioner has paid for the following beliefs. In the light of the fact that the order that has been assailed before this court has been passed by the authority by exercising jurisdiction conferred upon the authority under the Criminal Procedure Code, this court is of the considered view that the same cannot be allowed to be assailed under Article 226, as the same has to be assailed under the procedural law, which confers power upon the authority to pass the order. At this stage, on the request of counsel for the petition is allowed to be withdrawn with liberty to the petitioner to assail the order is to advise under the provisions under the appropriate provisions of the procedural law concerned. Yes, please, Dinesh. Yes, Dinesh Babu.
Yes, Lordship. Before I start, Lordship, that we have filed a civil suit in this case, Lordship, which is pending before the learned trial court, Lordship. But the reason for filing this,
we'll issue notice. We'll see about this. Huh?
Easy, Lord.
Notice. 1 से 8 के लिए सरकार reply in 4 weeks. This there. Date देखो जुलाई में.
Rainy season is started, Lordship.
बारिशें तो हुई. बारिशें तो हुई नहीं है. एक ही बारिश है पिछले कई दिनों में.
तभी कीजिए फाइल.
4 हफ्ते के बाद एक्चुअल डेट. Miss Meera Ramlal, ये क्या? 6/6/25. Reply to 110 not filed. If 110 not filed, छुट्टियों के बाद लगा दो immediately. List on 18. Reply in the meanwhile. Next. अब मेरा ये आपने रिप्लाई अर्जुन देव नॉट फाइल रिप्लाई टू योर एप्लीकेशन.
जी रिप्लाई फाइल कर दिया पर मेरे एज पर द इंस्ट्रक्शन ऑफ माय ऑफिस द हैंड मिसप्लेस्ड.
I've also filed my rejoinder.
मैं 18 को लगा दिया ये.
Your Lordship, can it be a week
after? Okay, no. इसमें लिखना लर्नेड मिस मीरा सर की प्रेजेंस लगाना. Miss Meera submits that reply to the application has been filed on behalf of the petitioner. Mr. Arjun submits that rejoinder thereto has also been filed. As prayed for, list for further consideration of the petition as well as the application on 25th of June.
Please, I'm deeply obliged.
Next, please.
Grateful.
25 sir. Raghuveer Dyas. Ashok. Contempt है ये अशोक. Okay. 4 weeks. 2 weeks में decide करनी है दोनों. या failing which? Failing. आप आ रहे? What's your good name?
Lordship, serial number D1 to D3 all are collected matters. Kindly have it.
आपका नाम क्या है?
Lordship, Digvinay Singh Kanwar.
नाम लिखना. अपनी कैपेसिटी में आ रहे हैं कि किसी के वाइस?
Vice Rahul Thakur, Lordship.
राहुल लगा. ठीक है, विजिटिंग कार्ड है?
Kind.
चिट है चिट.
Yes.
मैं सोचा विजिटिंग कार्ड है.
No, Lordship. Grateful, Lordship.
महेंद्र पाल शर्मा. ये भी आपका ही है, महेंद्र पाल. 6 weeks या 3 weeks में कर दो. Yes, Ajay.
Representation has not been decided yet.
फिर डिसाइड नहीं किया इन्होंने. 3 weeks पे डिसाइड किया. Vijay Chaudhary. Yes, Vijay.
Lord, I retired in August 24. My Lord, I have not.
Order क्या है dear?
Lord, it was decided in NECRAMS. The direction was to release my benefits within 4 weeks, my Lord.
Yes, sir.
Not received a single penny till date, my Lord.
Write the case. 6 weeks. 3 weeks में decide करो. Liberty. Next. Yes.
In this matter also kindly have it after 1 week, Lordship.
Ravinder Singh Kimta.
P6, Lordship.
पिछले विजय के केस में हो गया डिस्पोज ऑफ.
That has been disposed of.
Disposed of. Through counsel. Yes, please.
Your Lordship.
You can. Yes, ma'am.
petitioner and others are owner of the land donated by the Khasra number 470.
Notice, except for reply in 6 weeks. Next. Yes, Thakur Sahab.
Lordship. Petitioner file against the award passed by the Honorable Court, Lordship. Next
Show me the award.
Next piece 33, Lordship. Payment piece 43, Lordship. Land Court, Labour Court has held that there is violation of Section 25F, Lordship.
आप लगे कब थे?
Earlier 2009, Lordship, 9 to 13 work under the contractor, Lordship, and with effect from August 2023, Lordship.
निकाले कब थे आप?
12 June 2014, Lordship.
12 जून
2014, Lordship.
और आपने इंडस्ट्रियल डिस्प्यूट कब रेज किया था?
15 May.
3 में रेज हो गया था. Okay. Notice, accepts notice, reply in 6 weeks.
In this, Lordship, also this I challenge the award, Lordship.
इसमें भी अवार्ड ही है चैलेंज. इसमें क्या किया है कोर्ट ने?
Violation of
Notice 6 weeks. Presence लगा लेना. What's your good name?
You start on, my lord.
आप अपनी कैपेसिटी में? You should have for HP. वकालतनामा within 2 weeks. Reply in 6 weeks. श्री नीरज गुप्ता. ये क्या सर?
Application to bring on record the legal representatives of deceased respondent number 2A. Expired on 6th of September 2024.
ये और 151 में कैसे होगी एप्लीकेशन?
इसमें
पे क्या 22(3) तो लगाना ही पड़ेगा. प्रोसीजर तो वही रहेगा. You will have to come under 22 rule 3.
Here the application was filed under section.
So you have to order 22 rule. You will कम से कम प्रोसीजर तो फॉलो करो ना. प्रोसीजर तो फॉलो करना पड़ेगा आपको. Though the rigors, other rigors may not apply so stringently, but 151 थोड़ी है. You file an appropriate application under order 22 rule. 3 appropriate orders will be passed. Otherwise होता है ये फिर wrong trend शुरू हो जाता है.
The application was filed.
I am rejecting the application. I will not entertain under order 22. I don't know what happened earlier. I am again saying कि rigors नहीं लगेंगे. कम थोड़ी सी formalities हैं, है ना? इसमें लिखना on the request of learned counsel for the applicant, this application is ordered to be converted to an application filed under order 22 rule 3 of the civil procedure code. Mr. Jaswal has done the necessary corrections in the application in the court file under his signatures. आप कर दो इसमें यहीं पे, है ना? But ये गलत trend set होता है, इसलिए I am not in future में आपने by way of this application a prayer has been made to bring on record the legal representative of deceased respondent number 2A. Learned counsel for the applicant submits that respondent 2A, who was included as a party petitioner, no, who was included as party respondent in the year 2022, has expired on 6/9/2024, leaving behind legal heirs whose details are given in para 3 of the application. Accordingly, he prays that the application be allowed and deceased respondent 2A be substituted by his legal representatives. As there is no opposition to the application, the same is allowed as prayed for. Deceased respondent number 2A is ordered to be substituted with his legal representatives, whose details are given in para 3 of the application, who are substituted as respondent 2A1 to 2A4. Application stands disposed of. Mr. Jaswal has put in appearance on behalf of the newly included respondents. Wakalatnama, if not already filed, be filed within 2 weeks. Amended memo also in 4 weeks. इनको दे दो ये जसवाल साहब. सर आप करो. Yes, please. Chandar Narayan. Yes, please. Compliance not filed. किसने करनी थी?
Filed the compliance, though they have referred my case now for release of pension. But one thing I want to point out, we kindly have R4 they have next with the compliance affidavit.
Compliance नहीं आई है मेरे पास. आपने दिए फाइल किए? देना दो. है क्या उसमें कहते क्या ये?
ये दे रहे जी मेरे को 23 से पेंशन.
ऑर्डर क्या कहता है?
order बोलता है जी as per Lekhraj judgment. Lekhraj they have
You controvert it. इसमें लिखना learned additional advocate general submits that compliance affidavit has been filed, registry to place the same on record with in order. Mr. Devinder submits that he may be allowed to file response there to let needful be done within 2 weeks.
Great. My lord, in this.
Just 1 minute. Used to नहीं आएगा shall आएगा, है ना? Shall be.
Please, my lord.
Yes, please.
I have filed two petitions arising out of the same case, my lord. Because two separate order was passed. So one is listed and another is not listed, my lord.
Pardon?
Order, my lord. I have filed.
का क्या हुआ है?
वो पेंडिंग है, वो साथ ही पेंडिंग है.
Mr.
Was tagged.
ठीक है, इसमें लिखना Mr. Anil Chauhan please that there is another petition arising out of the same proceedings.
30.
WP number
Yes, sir.
30 of 2021, and it would be in the interest of justice in case both the cases are ordered to be heard together. List along with CWP number so and so as prayed for after 4 weeks. Yes, please, Ms. Dhiman. Yes, please. बताइए.
Get only 5 marks in 5th semester lordship due to
Give me the facts.
petitioner, my lord. He heard your lordship on in 5th semester, your lordship.
किस सब्जेक्ट में मैम?
BSc, your lordship.
BSc 5th semester.
Please, your
When?
maths, your lordship. BSc maths.
BSc math.
Please, your lordship.
कब मैम?
Sure.
Hmm.
This is the 5th semester result, your lordship.
Okay.
Exam was held on November 2019 and declared in the month of
July 7. Huh?
2020.
Okay. ठीक है मैम. फिर क्या हुआ जी?
On paper number 3, your lordship, he get 5 marks, your lordship.
Okay.
Then your lordship, he applied for re-evaluation, my lord, and by the next year P5, your lordship, he get 47 marks, your lordship.
Okay.
In the meantime, your lordship, he appears in the PG course, your lordship, for which he has to qualify the JAM exam, your lordship, which he has qualified on the very same year, my lord. And your lordship, and the 6th semester he appeared, your lordship, and he qualified the same also. But due to this 5 marks, your lordship, in next year P2, he could not get admission in the year 2020, your lordship. After qualifying the main entrance.
नहीं, just 1 minute. ये next P2 जो है ये कब इशू हुआ था?
ये June 2020, my lord.
June 2020.
Exam was held in the month of November 2019. your lord.
नवंबर के एग्जाम थे ये. ओके. और ये 6th सेमेस्टर के एग्जाम हुए जून में. 6th सेमेस्टर के रेगुलर एग्जाम्स भी जून जुलाई में हुए उन्हें.
Please, my lord.
हैं?
You mentioned in my rejoinder, your lordship.
Revaluation का रिजल्ट कब आया?
Sixth semester started in August 2020.
It started in August 2020. Okay. और एग्जाम कब हुए मैम फाइनल?
और 15 अक्टूबर 2020 में रिजल्ट डिक्लेयर हो गया.
15 अक्टूबर.
और रिजल्ट
सॉरी
जो है वो 28 अक्टूबर 2020 में दे दी गई.
जो इसका था
फाइनल मार्कशीट.
नहीं, जो क्या बोलते हैं इसको, रीवैल्यूएशन का रिजल्ट कब आया?
हाँ, रीवैल्यूएशन का रिजल्ट
October 2020, your lordship.
अक्टूबर 2020. अब बताओ आपका केस क्या है?
Now, your lordship, due to the less marks, your lordship, in 5th semester, your lordship, I could not get admission.
Ma'am, where is the question of someone getting admission on the basis of fifth semester marks? Until and unless a student completes the entire course,
Provisionally, Your Lordship,
even provisionally, where is the question of provisionally? Demonstrate that, please.
because Your Lordship, I appeared in the fifth semester. The fifth semester makes
Nahi.
me eligible to appear in the.
I understand that. Show me that particular exam which जिसमें ये clause था कि आप फेल हुए हैं या आपका नहीं आया तो आप नहीं बैठ सकते इस.
Your Lordship, I could not attend the counselings, Your Lordship.
मैम प्लीज अप्रिशिएट वन थिंग. मैंने तभी इनसे सवाल पूछे थे कि फाइनल रिजल्ट कब डिक्लेयर हुआ. You were rendered eligible only in the month of October 2020 when the final result is declared. It is not your case.
Final, Your Lordship, fifth semester result, sixth semester result, Your Lordship.
हम तो 6 सेमेस्टर फाइनली हुआ ना जी. 6 कितने साल का कोर्स होता है ग्रेजुएशन का? 3 साल का कोर्स है. तो 6 सेमेस्टर का रिजल्ट जो डिक्लेयर होता है अक्टूबर में. आई ऑल्सो पोज द क्वेरी टू बोथ ऑफ यू कि रीवैल्यूएशन कब आया? रीवैल्यूएशन साथ साथ ही आ गया हुआ.
Please, my Lord.
साथ साथ आ गया.
But Your Lordship, counseling for the this MSc course, Your Lordship, that was held in the month of August, Your Lordship.
Demonstrate that ना कि what was the criteria for admission in MSc?
Your Lord, I have to clear fifth semester.
मैम प्लीज दिखाइए ना कहाँ है वो. ब्लैक एंड व्हाइट में शो करिए. मुंह जुबानी नहीं. क्योंकि I don't understand one thing, that if the result of the fifth semester was not declared up to June 2020, where is the occasion of counseling taking place in June 2020?
In August 2020, Your Lord.
मैम अगस्त में भी फिर मेरे को आपको बताना पड़ेगा ना. आपको काइंडली आप थोड़ा इसमें डू योर होमवर्क. आस्क द पिटिशनर. आपको सप्लाई करेगा वो है उसमें. इसमें लिखना on the request of learned legal aid counsel, the hearing of the case is deferred by 4 weeks to enable the petitioner to place on record documents to demonstrate that on account of the wrong evaluation of his answer sheet at the first instance, he lost the opportunity of getting admission in the MSc course in the session commencing from the year 2020. ठीक है मैम? List on dash. जुलाई की डेट दे दीजिए.
Time to file rejoinder, Your Lordship. File by the respondent, Your Lordship.
Reply miscellaneous application का.
Yes, Lords, my Lords, I beg to appear on behalf of the applicant.
Yes, please. Yes.
We have moved an application for withdrawal of the amount which they have deposited.
Okay.
That matters, I have to file a reply, Your Lordship.
They have not filed reply. It's coming for the first time. That application is coming for the first time.
For the first time.
We'll grant them some time to respond there.
Lords.
If I get a notice, ma'am accepts notice, reply in 3 weeks. This thereafter. The list on dash. July की date दीजिए. Yes, please. Parav Sharma. Yes, Parav. That's not fine. Yes, Mr. Sharma.
Order Lordship.
I am saying that we are not compliant with the audit till now, Lordship. I am saying that my lord will keep it on immediately after opening of the court vacation, Lordship. Surah Satar or my lord may keep it after lunch. I will call the responsible officer.
तो मैंने उनकी शक्लें देख के क्या करना? We are interested in the compliance of the
Yes,
judgment.
Lordship. And my lord can take up the matter after the 17th, Lordship.
Then फिर क्या होगा?
I will ask them to do the next.
और अगर नहीं हुआ तो
It will be done, Lordship.
देख लेना. इसमें लिखना अपने learned additional advocate general submits that in the interest of justice some more time be granted to comply with the judgment in issue in letter spirit. On his request on dash, failing which the competent officer shall remain present in the court to explain as to what is the what is the deterrent in implementing the judgment in letter spirit. Next, छुट्टियों के बाद से actual date दे रहा हूँ. 18th sir, What is the impediment कर देना deterrent. What is the impediment? Yes, Shri Ashok Kumar. इसमें क्या हुआ? Honorable Division Bench के पास अभी चला हुआ मैटर?
और stay है.
Stay है.
This is that.
Stay, Praveen.
That matter is still sub judice, Your
तो
Lord.
फिर we'll I'll adjourn it by 8 weeks.
Please, Your Lordship. Please, Your Lordship.
ये इसमें लिखना learned counsel for the parties inform the court that the letters patent appeal
Please, please.
is still pending adjudication before the Honorable Division Bench. As prayed for, let these petitions be listed in due course with liberty to the parties to make a mention for listing of the petitions in case any such eventuality arises.
Please, Your Lordship.
You know, arises which calls for the listing of the execution petitions.
Grateful, Your Lordship. Next is also same.
Same order, sir. Yes, Goel Saab, Miss Maheshwari. Compliance affidavit, ma'am. Compliance.
I have
Yes.
instruction, Your Lordship.
No instructions.
No instruction.
Notice, Doga sir. Notice.
My lord, they have already, she has already attended.
Notice देना पड़ेगा. Learned counsel praise instructions. You will have to serve a notice on HPTDs.
Well, these are large number of cases, my lord. I have already served and they have.
Sir, you are serving the person who they do not accept as the representing counsel in the case. That is the issue.
Your Lordship, this is a 24 year case.
हाँ. नहीं तो मैम आपने अगर instructions देनी तो I'll give you time.
Yeah, just your,
तो आप कह रहे हैं.
I will give it.
Ma'am prays for some more time to file compliance affidavit. Let this be done in 4 weeks.
Obliged, Your Lordship. Obliged.
There are.
Yes, please. Chandan, date दे देना. Date देंगे सर आप. Date. चलो. Date दो. Chandar. 15 July, sir.
Obliged, Your Lordship.
Yes, please.
Judgment page 53.
हाँ.
Relevant would be para 4.
Okay, अब क्या हो रहा है?
Though I have been re-engaged, but no salary has been released in my favor since May 2024.
फिर वो अलग बनेगा केस, इसमें तो नहीं होगा वो. हाँ?
Because I am working since 2024 and they are
No. Have they re-engaged? एक minute, just 1 minute.
They are saying that this judgment of division bench has been assailed before the apex court, and one of the matter there is interim order. Though came lordship,
नहीं, आप हाई कोर्ट क्यों आए थे?
हम आए थे जी रेगुलाइजेशन के लिए, and status quo order was passed. And we are continue from that very date.
What were the directions given in para 50 of the judgment?
Para 50 that they should be regularized in terms of the this policy framed by the state government.
Okay, so what is their stand?
Their stand is, lordship, for that, lordship, they are saying that they have assailed the judgment before the apex court.
Which judgment?
This lordship, this division bench judgment, my lordship, this
रूपलाल वाली?
Rupal.
तो फिर ठीक है, then you have to wait.
Yes, my lordship, I'm regularization, I'm not at
You
this.
will not get anything. ऐसा है ना, अगर आप चाइनीज रेस्टोरेंट में आए हो तो वहां पे
Lordship,
खाना भटूरा तो नहीं मिलना ना.
on the petitioner,
Or no, that grievance is totally different. That is a totally different grievance. It has got nothing to do with this case. यहाँ पे आपकी लिमिटेड प्री थी कि there is a division bench judgment, उसके हिसाब से regularization, give us regularization. They say that we have challenged it. So till the judgment does not attain finality, High Court will not force them to implement.
that
तो तनख्वाह नहीं दे रहे हैं आपको, नया केस बढ़ाओ.
नहीं है जी, बाकी
गरीब होते हैं.
because they are 2024.
थर्ड वर्ल्ड कंट्री में सारे ही गरीब हैं. इसमें नहीं बनेगा. It's you better advise your client to file a fresh petition. That is the
I have that, I have.
तो फ्री में कर दो काम. उसमें क्या है? फ्री में कर दो. एक केस फ्री में फाइल कर दो.
लordship, इसमें आ जाए जी कि
मैं नहीं करूंगा. आप इंडिपेंडेंटली फाइल करो.
नहीं, मैं कर लूंगा जी, मेरी सबमिशन आ जाएगी सैलरी के लिए.
Okay,
Independent.
in light of the fact that the judgment on the basis of which the petition of the petitioner was disposed of stands by the respondents before the Honorable Supreme Court of India,
There is stay, my lord.
and there is stay granted in favor of the respondents as has been intimated to the court. No order at this stage as prayed for can be passed in the execution petition. Accordingly, the hearing of the petition is deferred by 8 weeks. At this stage, Mr. Devinder Sharma, learned counsel appearing for the petitioner, submits that despite the fact that the petitioner is regularly serving the respondents, his salary is not being reviewed.
Since May 2024.
All that this court can know is that as the same is a different cause of action, the petitioner would be well advised to have such recourse to his grievance as he may be advised. Dependent डेट करो उसमें मिल जाएगी आपको. Yes, please.
This has come.
Yes, क्या sir ये?
This is a lordship objections under section 34. Lordship's reply stand filed. I'm seeking some time for filing rejoinder.
Just 1 minute. इसमें है क्या issue क्या हुआ है? Section 34 है ये. Okay, reply to the petition stands filed on his request to join within 4 weeks. Is there? Revival of petition. Notice. Yes, ma'am.
Is partially complied
Sir को देखो.
and the remaining amount is scheduled to be paid in.
May have the order passed on 24 February 25 lordship. They have undertaken to make the payment lordship within 6 weeks lordship.
हम कितने टाइम में दोगे?
अब ये installments में कर दिया जी.
Installment.
Installments में नहीं देनी पड़ेगी. You will have to pay.
4 installment कर दीजिए.
नहीं 29 तक थोड़ी.
They have undertaken to make the payment within 6 weeks.
थाना सर order
24 February lordship 25. In the execution which was disposed of lordship.
Learned counsel ने इसमें लिखना ऐसे करो. OMP में notice में accepts notice. List on dash reply in the meanwhile. 2 हफ्ते बाद रख रहा हूँ reply in the meanwhile to the application for revival.
For revival lordship.
हाँ उसी में करा मैं.
Lordship.
उसी में notice किया सर. 2 हफ्ते बाद लगा दिया मैंने.
Please, Your Lordship. This is execution.
Yes, sir.
Coming up for the very first time, Your Lordship.
The notice.
Please notice.
4 weeks.
Notice.
इसमें decision का ही है. Decide करने का.
Supposed to be decided
2 हफ्ते revival आपके.
Observation maybe that revival chat maybe on the oral request, Your Lordship.
Oral request नहीं होगी. एक 4 लाइन की application तो देनी पड़ेगी.
Without affidavit.
Without affidavit to file it.
Please. Next is also a similar matter.
Failing which the petitioner shall have the
23.
Seek revival of the
24 to 30 are similar matters, Your Lordship.
by filing an application, and registry shall not insist upon the application being accompanied by the affidavit of the petitioner. ठीक है?
24 to 30.
ये सब में कर दिया करो जिसमें liberty देते हैं ना revival का right. The registry will not insist upon the application being accompanied by the affidavit of the petitioner. Yes, please. Pradeep Verma. Yes, Verma ji. Execution. 8 weeks from today, it will be disposed of. 3 weeks. Failing which? Verma ji, 3 weeks. Failing which? Right to revive. Yes, please.
Lordship, this is my execution petition. Execution of judgment dated 10/3/2023. Lordship, we had claimed regularization after
3 weeks. Decide करो. Next. Revival का right.
Good Lordship.
कितने हो गए सर? कितने हो गए? 54 हैं कि 54 रह गए? बस. Yes, please. Two weeks. Decide करो. Notice करके decide within 2 weeks. Failing which? Pardon? What's your good name? Vice.
Please, Lordship.
Disposed of. Decide within 2 weeks.
Lordship, these are all connecting matters from 31 to.
Yes, Mr. Jagdish Thakur. कर दिए सारे disposal. Release of amount deposited. Pass on. Recalling order date. Yes, please. Yes, please. ये क्या? What is your application?
Matter has been disposed of in terms of Surjmani Lordship.
हाँ.
So that work just itself. Whereas Lordship, we are claiming for the regularization Lordship.
But these orders are passed in your presence.
Connected matters थी ना जी.
हैं? कौन से किस केस में दी आपने ये?
कामता देवी में
एक केस में है ये?
हाँ जी, एक में ही है. 13 पे है जी.
40.
हाँ जी, हाँ जी.
इसमें लिखना in the light of the averments made in this application, the same is allowed. And order dated 21 March 2024, passed in CWPOA number 7487 of 2019 and connected matters, is recalled as far as CWP number 4540 of 2021. The petition is ordered to be restored to its original number. With the consent of the parties, the petition is also taken up for final consideration today. Learned counsel for the petitioner submits that interest served in case this petition is disposed of with the direction that letter appropriate order be passed on the prayer made by the petitioner in the light of the judgment passed. किस केस में?
सूरजमणि के बेस पे डिसाइड हो गया था ना जी.
किसके बेस पे कराना है आपने?
ये इंडिपेंडेंटली सुननी है जी.
है क्या ये
रेगुलराइजेशन.
ओके, फिर उसको उसमें इंडियो लगा देना है ना, रिस्टोर करा देना.
हाँ जी,
सिर्फ एक ही केस है बाकी
एक ही है जी इसमें. पेज 13 पे.
बस उतना ही आएगा ना. रजिस्ट्री इज डायरेक्टेड रिस्टोर इट्स टू इट्स ओरिजिनल नंबर एंड लिस्ट फॉर फर्दर कंसीडरेशन आफ्टर 2 weeks. ठीक है, चल. यस, मिस्टर अनीता मोक्ता. मिस अनीता मोक्ता. यस मैम, लेबर कोड का अवार्ड चैलेंज कर रहे हैं आप?
Yes, Lordship. Petitioner is aggrieved by the order of the
इसको करना पैरा बंद में ना भी करो करना 27 में. मैम मैं 27 को ना 6226 करो, साइन कर देना. यस प्लीज.
The petitioner is aggrieved by the order of the tribunal dated 30th November 2023, passed by the presiding judge, Labour Court Committee Tribunal in case reference number 84/2019 Lordship. In case title as Mustaq Ali versus.
Why according to you the award is bad?
Yes, Lordship. Lordship, the copy of the judgment is annexed as page.
That वो पढ़ तो मैं भी सकता हूँ, मैं आपसे पूछ रहा हूँ. According to you, आपने बनाई है ना petition?
Yes, Lordship.
Explain in your own words why the award is bad.
Lordship, the termination of the petitioner from the service of the petitioner is against the provision of ID Act, Lordship. Interstate dispute.
Which particular section has been violated?
Lordship, the section 25F, section 25F, condition precedent, Lordship.
So when was his services terminated?
Lordship, the petitioner is terminated. Lordship, the petitioner initially engaged on the basis of implied contract on dated 8th May 2013, and petitioner was continuously worked with the respondent till 29th October 2015, Lordship. Lordship, the section 25.
Yes.
Condition precedent of retrieve workman, Lordship. No workman employed in any industry who has been in continuous service for not less than 1 year under an employer shall be retrieved by the employer until the workman has been given 1 month's notice in writing indicating the reason for retrievement, and the period of notice has expired
or the workman has been paid in lieu of such.
How do you assail the findings of the learned labor court, जहाँ पे उन्होंने ये बोला कि जो आपने तनख्वाह की रसीदें दी थी ना,
Yes, Lordship.
उन तनख्वाह की रसीदों के हिसाब से आप बहादुर के एम्प्लॉई थे.
Yes, Lordship. Lordship, the relevant para at page 25, para 22. There is nothing in the evidence of the Roshan Madhan RW1 from which it could be inferred that petitioner was engaged by the respondent.
Notice to the respondents return for dash. Court notice करना है ना, court notice to the respondents being a legal returnable for dash. Shri Viri Kitta, yes please.
Lordship, the matter is coming up for the first time. Your Lordship may directly have the impugned order P19 on page 74, Your Lordship.
Okay, what is it?
On account of the earlier litigation and the order of this honorable court, this order was passed, Your Lordship.
No problem. Notice, except for 6 weeks.
Please, gratefully, Lordship.
Tell me. Yes, Mr. Jagdish Thakur. Yes, please.
They moved an application for the release of amount.
What do you say?
No objection to release the amount, Lordship.
Release तो पहले हो चुका हुआ है.
और उसके बाद नहीं होता बीच में.
पर मंथ डिपॉजिट हो रहा सर, इनकी सैलरी पर मंथ डिपॉजिट हो रही सर.
हर मंथ की सैलरी इनकी डिपॉजिट करते हैं बिफोर द रजिस्ट्री ऑफ जी.
फिर तो इनको हर महीने ही एप्लीकेशन देनी पड़ेगी.
ये भी डिपॉजिट है जी सारा.
इसमें लिखना notice accepts notice on behalf of the respondents. By way of this application, a prayer has been made for the release of the amount which has been deposited by the non-applicant petitioner with the registry of this court relating to the wages of the petitioner. As there is no objection to the application, the same is disposed of with the direction that let the amount which now stands deposited in the registry of the court be released in favor of the petitioner in his bank account. Details whereof are given in the application. Application dispute. Yes, please. Amrik. ये क्या सर?
Yes. Against the aggregation.
And
Mr. Dalip K. Sharma was representing.
Amrik Singh आ रहे हैं. 24/3 को अमरीक ने प्रेजेंस लगाई है. रिप्लाई ऑन रिकॉर्ड रिजॉइंडर वगैरह फाइल नहीं हुआ अभी इसमें?
नहीं जी.
पास ओवर कर देते हैं. बार अब अमरीक सिंह का नाम दिखाओ जरा. यस पंडित जी.
Status quo.
Okay.
The matter pertaining to the filing of the heads over the private land ownership.
नहीं हुआ क्या ऑर्डर? सर को भी दो, पंडित जी को. इसको फिर उसके 13/8 को रखा है सुप्रीम कोर्ट ने, उसके बाद रख ले. Learned Deputy Advocate General has apprised the court that in the miscellaneous application that was filed by the state before the Honorable Supreme Court of India, Honorable Supreme Court has been pleased to call upon the CEC to examine the issue and submit its report within a period of 8 weeks. The matter is now listed before the Honorable Supreme Court of India on 13/8/2025. In the light of this development, as prayed for, this petition is ordered to be listed on 25/8/2025. Yes, please. Yes, Amrik, इसमें आप आ रहे हैं ना? इसमें रिप्लाई आ गया, रिजॉइंडर नहीं आया है. रिजॉइंडर 4 weeks, 6 weeks. Rijoinder 4 weeks ही करना, लिस्ट देना. Yes, please.
In this case, we have filed the rejoinder to the reply filed by the state.
What is the matter, sir?
Well, the matter is with regard to some allotment of land was made in the year.
Okay.
So far as the individual is concerned, he was not eligible. He was a government employee.
Rejoinder not filed.
We have filed, my lord.
Okay, then senior counsel for the petitioner submits that rejoinder to the petition has been filed. Registered to place the same on record is there. Yes, sir. Shri Ajay Sharma. Kulwant Singh, ये क्या है सर? इसमें लिखना 12837. This application is disposed of by taking on record the factum of the death of respondent number 5. Ajay ji, respondent number 5 is dead. R5 is dead. किसने एप्लीकेशन किसने दी है ये? मैम आपने दी है? On the request of the senior counsel appearing for the petitioner, 4 weeks time is granted to bring on record the legal representatives of deceased respondent number 5. This thereafter. In the meanwhile, pleadings be completed by the party. सर ये दोनों में है?
हाँ जी, दो
कौन सी? मैम आपने दोनों में दी है एप्लीकेशन? ठीक. Interim to continue. Yes, Mandeep Chandra.
As for last order, Lord, nothing has been done by the corporation, Lord.
Okay. Yes, please. या कुछ?
Nothing is due in receipt.
Just 1 minute. What do you say? कहते हैं अब तो देना ही कुछ नहीं है.
They filed the affidavit, Lord. They filed the.
आपने खुद ही बोला था.
I'll file the counter in that.
No, you. आप अब कह रहे हैं कि कुछ देना नहीं है. Are you not contradicting your own statements being made in the court? Huh?
Give this said we have been taken the decision, and as per the BOD decision, I have.
आपको पैसा मिला या नहीं मिला, चाहे किस्तों में मिला चाहे कुछ नहीं मिला?
Only यही मिला है जो दिया है.
सर ये कह रहे हैं that this is all you were entitled to. आपका नाम क्या है?
मोहन.
और दूजा?
चंद्रमणि शर्मा.
Enhanced DA ही मिलना था आपको सिर्फ इसमें. एरियाज कैलकुलेटेड और 16,000 और 2848 ये इन्होंने कह रहे हैं हम पे कर दिया हुआ है.
ये नहीं, अमाउंट ज्यादा है जी. ये they have only ये.
Okay, don't worry. इसमें लिखना learned counsel for the respondent corporation has handed over instructions in terms whereof the order in issue complied with the enhanced DA and the areas of the enhanced DA to the tune of 16,601 and 2,848 payable to Mohan Singh and Chandar Mani Sharma have already been paid. Learned counsel for the petitioner refutes this fact. He submits that the case be taken up after 2 weeks to enable him to file an affidavit in this regard. Ordered accordingly, list after 2 weeks.
Because this is the enhanced area since 2014.
कोई बात नहीं सर. इसमें लगा देना ये. Yes, please. Bhavya Sharma. Yes, ma'am. Okay, reply stands filed, rejoined in full.
In this matter, Your Lordship, I had moved an application for 17B, Your Lordship. I has also been filed, Your Lordship. That
17B का क्या कहते हैं आप?
Lordship, they have not even denied my averment, Your Lordship. That may kindly be allowed.
Who is the learned counsel?
Lordship, Advocate Rupinder Singh Thakur. I am appearing vice lord.
Who is to argue the application?
Advocate Mr. Rupinder Singh Thakur.
उनको बोलो कब गैस करेंगे?
Lordship, 2 हफ्ते बाद रखते हैं.
एक आप रिजॉइंडर फाइल कर दो. आफ्टर मैं एक्चुअल डेट दे रहा हूँ सारा भी.
Lordship, please, Your Lordship. Please, Your Lordship.
लिखना
Lordship, I submit that award is a short one, Your Lordship, can be disposed of if they.
डेट पे देख लेंगे.
Please, Your Lordship.
इसमें लिखना आपने list on dash as paid for rejoinder in the meanwhile. On the said date application filed under section 17B of the IDA shall be considered.
Please, Your Lordship.
2 हफ्ते के बाद.
Grateful, Your Lordship.
श्री सुमेश शर्मा. 5 ने दिया ठाकुर साहब.
4 का वेटेड है जी, पर हमें रिजॉइंडर फाइल कर दिया जो हमको कॉपी मिली है.
नहीं 1 से 4 का नहीं आया सर अभी. इसमें लिखना reply has been filed by R5, reply by R1 to R4 within 4 weeks. In the meanwhile, rejoinder be filed to the reply filed by R5. Dismiss thereafter. Yes, please. Shri Vinay Sharma.
This one of the similar matters have been ordered to be listed in due course. 4 or 5 matters are all already there, pending a lot. This is regarding this MBBS admission courses one. Domicile and all.
List in due course.
LWP number 11771.
None for the petitioner, list in due course. Chaliye. Yes, Mr. Bhardwaj.
Lordship, I am seeking time to rejoinder. Replies filed by respondent.
Boharu mein. Reply stands filed, rejoinder within 4 weeks. This year. Yes, please. Kamakshi. Compliance affidavit not filed. Yes, ma'am. Judgment is of the Honorable Division Bench. Okay, let the sir. They are, ma'am. Sir, they are saying that they have filed an SLP.
Please, Your Lordship was dismissed.
SLP has been dismissed.
Your Lordship, the order has been placed on record. As
Page, ma'am.
6, Your Lordship, annexure C2.
Okay, no problem. State of HP versus Upinder Kumar.
They are all connected cases.
Connected cases.
Here, compliance affidavit not filed. 3 weeks. List on dash.
Obliged.
Compliance affidavit in the meanwhile. Yes, sir. Compliance filed by DC Shimla. ये क्या sir case? Okay.
On the last date of hearing, my lord.
Yes, please. DC.
Directed to the deputy commissioner, my lord, to file a affidavit.
Let us see what the learned deputy commissioner has to say. Deputy Commissioner. Himuda, as per the report of the Deputy Commissioner, remedial measures have to be taken by you. You respond to it within 1 week. ठीक है?
ठीक है.
इसमें करना Deputy Commissioner Shimla has affidavit in terms of the actions passed by this court. On the request of Mr. Chandan Narayan, list on dash to enable him to file a response thereto, as it stands spelled out in the affidavit filed by the Deputy Commissioner Shimla, that remedial measures will have to be taken by Himuda.
My lord, in the meantime, the vacation orders may be stayed.
So that already order has been passed by me. How can I stay the order? Huh? मैंने सर I have dismissed the application. Please read the previous order. Next. 10 दिन के बाद छुट्टियों के बाद लगा देना. I've already passed a speaking order on the application. Huh? Sir, problem is how can the High Court आपने खुद application file की. आपकी application पे they have declared it as unsafe for residing.
To provide the financial.
That is not how का High Court का क्या concern है. That is sir, that is not the judge. That High Court cannot do. High Court can't do. To file a civil suit for damages then at the most.
That is always entreated by the report of the deputy commissioner.
Who will assess the damages? We will have to lead evidence. Evidence has to be led. Let us first see what Himuda says. What Himuda says. Himuda, there are two situations. A is, will it be worth spending crores and crores of rupees in constructing a danga? Alternatively, अगर है तो इनको decent सी compensation देके इनको वहां से खाली कराओ, ले लो आप इनकी जमीन वगैरह, उसको बाद में यूटिलाइज करते रहो प्रॉपर्ली जो आपको नहीं, मैं इनको कह रहा हूँ, ठीक है? कुणाल वर्मा, यस कुणाल, इसने R1 और R2 ने किया फाइल है, बाकी उन्हें नहीं किया है।
इन पार्टी यही है।
In party, okay.
Issue is only with regard to the kindly revoke my cancellation of GST lordship. My has been cancelled since March 2024 lordship.
You want to argue it now,
lordship?
Yeah, I submit one. It is a tax matter. It is my submission. And the Honorable DB1 has the roster and already such kind of a matters.
GST वहीं जाते हैं.
GST वहीं. Tax matter. So
tax matter.
I am.
Yeah, and you are 100%.
Because it is a tax.
Don't worry, sir. No, you should point out these things.
My lord.
इसमें लिखना, the court stands informed that as the issue raised in this petition relates to GST.
My lord.
And as Honorable Division Number 1, as per the current roster, is dealing with tax matters. The court stands informed that the issue involved in this petition is regarding GST, and presently, Honorable Division Number 1, as per the current roster, is presiding over the matters relating to taxation in a full stop. Register is full stop. In this view of the matter, register is directed to list the case before the appropriate bench. Measure of honorable. Rajni Gandhi. Yes, please, Rajni.
By presence में kindly mark on.
Yes, Rajiv.
2 my lord and 4 weeks में kindly granted to file a reply.
Just 1 minute. R2 served Jagat Pal accepts, has put in appearance, reply in 4 weeks. Is this thereafter? Okay. Yes, Shri Anand Sharma. Respondents 5 to 7, sir.
I am appearing.
Yes, Anand.
I am appearing.
No replies have been filed.
Okay, don't.
I am appearing for respondent 5 to 7.
Okay, 5 to 7 served has put in appearance. Reply not filed by any of the respondents. 3 weeks, list on dash. Yes, Dr. Lalit. Yes, Rajiv, पूछा आपने?
They have taken permission.
They have taken permission. फिर पंडित जी.
My lord, because in the face of section 32, but my lord can see क्या दिया है. ये फिर इन्होंने मिसकंस्ट्रू किया सेक्शन 32.
किसने?
ये इस ऑर्डर के अंदर.
तो आप इसको चैलेंज करो अगर आप ये है.
नहीं, मैंने इसमें लिखा हुआ है जी, इसके अंदर जो मेरा रिलीफ है ना जी. आई एम सेइंग दैट let the general house be convened strictly in the sense of this.
That is not the High Court's job. You came here, पंडित जी, ऐसा है ना?
Yes.
सुनो मेरी बात.
Please, Lord.
सुन लिया करो कभी. ठीक है ना? आप कोर्ट में आए थे.
Right.
Found that AGM was being convened.
Yes, Lord.
Violating the provisions of section 30.
Yes, Lord.
Rajiv now submits.
Please, Lord.
That they have sought the permission of the registrar.
Please, Lord.
Let's pause here.
Please, Lord.
Whether the permission is good or bad,
yes, Lord.
It can be assailed under the provisions of the British Society Act. So High Court is barred.
नहीं नहीं मिलो.
मुझे बड़े दुख के साथ.
नहीं मिलो. Let me.
तेरी jurisdiction.
मैं बता रहा हूँ. My lord, the section 72 lordship under the Cooperative Society Act, it deals with the lordship. Any action of lordship of the authority concerned can be challenged by way of the arbitration proceeding. Section 72 lordship. Now, and when the lordship, the purported action of the statutory authority is ipso facto lordship, the illegal lordship, then a lordship that the plea of statutory plea, alternative plea, etc. lordship will not.
There is no question of alternative plea. You have statutory remedies. I
understand. ये नहीं provision हो सकता. I cannot check because he is the registrar lordship.
So,
external registrar is registrar lordship. Then
72 does not come into picture. 72 a dispute between you and the society.
Society.
But now here, rightly or wrongly,
they
are convening an AGM.
Yes, Lord.
On the basis of the directions passed by a statutory authority.
Yes, Lord.
If you are aggrieved, invoke 92, 93 and 94 जो भी है, वहाँ है remedy आप. आप 20 सेक्शन पीछे ही रुक गए थे।
Just lordship.
हाँ,
Because my lord is keeping in view of the my lord. My lord, here my relief clause is seen, lordship. I have stated because in the specific pleaded cases, when a lordship I approach the authority concerned to supply this document, he says you apply under
RTI.
under RTI. Then the lordship, I challenge that because I presume that some sort of permission has been granted, lordship, and that action is challenged by me in the present.
That I am not going to go into. Please read the provisions of the Cooperative Societies Act.
Please, sir. Right.
Any order passed by this authority is appealable.
Please, sir.
So challenge it under 93.
In 93.
और क्या? अधिकारी द्वारा पारित कोई भी फैसला, सेक्शन को क्या बोलते हैं हिंदी में? अधिनियम। अधिनियम है, धारा 93 के तहत।
नियम धारा तो फिर वो
भी है,
बाय लॉज आ
ये नियम रूल होते नहीं, फिल्मों में क्या बोलते हैं? धारा 302, धारा ही होगा,
सेक्शन धारा सेक्शन
302। आज ही रातें हिंद। ये नहीं है, योर रेमेडीज अंडर 92, 93 एंड 93।
मतलब 93 में देखेंगे, मतलब सॉरी लॉर्डशिप 93
नियम, अधिनियम भी होता है कुछ,
अधिनियम एक्ट होता है,
एक्ट इज अधिनियम, सॉरी, यस।
In 93, my lord, this is the order. This 93 lordship. It says an appeal shall lie under this section against an order of the registrar made under section
93. Please come to the revisional powers.
Revisional
powers.
The state government, except in a case in which appeal is preferred under section 90, may call for examine the record of any query or inspection held under the sector and proceedings. Then, my lord, because since this has come along,
तो आप इसको
yes, lord, so that I can today itself, lord.
फाइल वापस करो।
Yes.
इसमें लिखना आपने।
Otherwise, I was saying, lordship is a per se illegal lordship because under proviso 2 lordship, he has no authority lordship.
Okay, no problem. I'll allow your writ petition. Rajiv, do you agree it is per se illegal?
नहीं जी,
मना कर रहा है।
नहीं, मेरी और इनकी है कि नहीं,
अगर आप यूं होते तो इसने
प्रोविजन 2 की बात है जी। एंड मैं एक इसमें क्लॉज 4D में लिखा हूं, मैंने रिलीफ नहीं की
बाय वे ऑफ दिस पिटीशन।
एक सॉरी सर, मैं सॉरी आई एम क्लॉज में रिलीफ C में लिखा हुआ सर, respondent number 3 may kindly be directed to invoke his power which is vested in him under section 32 for the purpose of convening the meeting of the general house of the respondent post as per the last proviso of the immediate section. I am saying okay, I have no problem in case he convenes.
High Court will not issue any mandamus for the reason, why should I presume that the officer shall not be acting in accordance with law? You see, in terms of the provisos, rightly or wrongly, power is conferred upon the registrar to ignore the delay, if he so deems it fit. If you are aggrieved by that exercise of discretion by the officer, challenge it, sir. Court is not even remotely suggesting that the order is good or bad. But your remedy is not High Court under Article 226 in this. इसमें लिखना by way of this petition, the petitioner has inter alia assailed notice dated 30th of April 2025, issued by respondent number 4 for convening of a journal house of the society on 8th of June 2025. पहले नोटिस करना 1-3 के लिए, 4 के लिए राजीव के कर देना। Dr. Sharma, learned counsel for the petitioner, primarily argued that the impugned notice was per se bad for the reason that as the last AGM was convened in the month of August 23, sir.
Yes, my lord.
On 3rd of September 2023. The society had no authority in law to convene any meeting by bypassing the provisions of section 32 of the Cooperative Societies Act, more so the provisos thereof.
Yes.
On the asking of the court, Mr. Rajiv Rai, learned counsel appearing for respondent number 4, sought instructions from his client as to whether any permission was sought from the statutory authorities by the society to convene the annual general meeting or not. In terms of the instructions imparted by Mr. Rajiv Rai on the strength of communication dated 2/5/2025 addressed by the Office of Assistant Registrar Cooperative Societies, Bilaspur District, Bilaspur, to respondent number 4. He apprises the court that necessary permission was taken from the statutory authority by the society. In the light of this development, Dr. Sharma Press Fund is allowed to withdraw the petition with liberty to the petitioners to assail the permission so granted in accordance with law. It is clarified that this court has not made any observation for the legality or illegality of the permission granted by the statutory authority. Next case. इनको दिया आपको थोड़ी देनी, इनको थोड़ी देनी.
Avail me law statutory authority.
मैं सोचा आप इसको कह रहे कि राजीव को लिबर्टी दी. ये ठीक कर रही इशारा क्योंकि दफ्तर इस साइड है ना रजिस्ट्रार का. इसमें ऐसे करना लिबर्टी के साथ निशान भी लगा देना एरो मार्क. यस प्लीज. प्रदीप कुमार. इसका साइन है अपने.
Please, madam.
इसका साइन है.
Information of arrest is there. I am not disputing that.
हाँ.
But
Grounds of arrest. Grounds of arrest. चलो I'll issue them notice. Let us see what they have to, है ना. इसमें लिखना पर notice confine कर रहा हूँ मैं फिलहाल. Respondents 1 to 5. मैं इसमें लिखूंगा कि आप कह रहे हैं कि grounds of arrest नहीं दिए हुए हैं. आप किसके लिए आ रहे हैं विजय?
सी के लिए.
Okay. इसमें लिखना notice to respondents 1 to 5 to enable the said respondents to impart instructions that as alleged by the learned counsel for the petitioner, whether at the time of the arrest of the petitioner the grounds of arrest are intimated to him or not. In presence. Number 3, what's your good name, dear?
Gaurav Kumar.
Mr. Gaurav?
Gaurav Kumar.
Has put in appearance on behalf of R3 on his instructions. Then senior counsel has put in appearance. List on dash to enable the said respondents to have instructions on the said time. छुट्टियों के immediately बाद sir. Because अगर नहीं दिए हैं तो then consequences will ensue. That is the only limited ground now. उसके अलावा नहीं है कुछ भी.
Otherwise, my lord, इसमें जी they are running extortion racket. इसको जिस तरीके से फंसाया गया है, इससे पैसे की डिमांड, रिकॉर्डिंग्स, मॉनिटरी ट्रांजैक्शन मैंने सारा रिकॉर्ड कराया जी.
चलो next case देखते हैं. Let us first see this. ये रख लेना आपने. Judgment रख लेना. ये वही है ना पीएम लेवल जिसमें भी हम ठीक है. But that's all. खत्म. Very good. Yes, yes, Tushar.
Workman matter, I may pray for any date, your lordship.
ले लेना. हाँ 2 हफ्ते बाद रखा है ना वो. डेट नहीं दिया वो.
No date was given. Please, your lordship.
Thank you.
Grateful, your lordship.
Enjoy your holidays.